We can access it from the lens of Christian succession law or inheritance law, but actually tells us something more about the position of inheritance. So it's not just a question of reforming inheritance for non-Muslims, it's also the question of reforming inheritance for Muslims. And the two, of course, do not go undivided.
Welcome to Minority Law to Go, the podcast where we explore the intersection of law, gender and religion, and state power across the Arab world. I'm your host, Dörthe Engelcke. Today, we're delving into the role of law and religion in Egypt and rights of Egyptian Christians to apply their own inheritance laws. I'm honored to be joined by Gianluca Parolin. Gianluca is a professor of law at the Institute for the Study of Muslim Civilization of the Aga Khan University in London, where he also leads the governance program. He's a comparative lawyer working on constitutional law, state-Islam relations, citizenship, shifting semiotics of law, and images of law in popular culture. Gianluca, thank you so much for being here. Ahlan wa sahlan.
Thank you for having me here, Dörthe. It's a great pleasure. Ahlan bik.
Gianluca, you are a scholar of comparative law. You've written extensively on law in Egypt, representations of law in popular culture, really interesting work on how law is addressed in television series and legal theory. And more recently, you've turned to the question of inheritance rights of Christian minorities. Could you explain why this topic is important?
It actually developed sort of naturally from my work on the case law of the Supreme Constitutional Court in Egypt, in specifically looking at their case law on Article 2, which is the article that provides for a specific position for Sharia in the legal system of the country. And what I noticed by looking at that case law was that the Supreme Constitutional Court took a very specific position on the inheritance rules. So it sort of set inheritance rules apart from other parts of the broader Shariatic normativities. And in doing so, it sort of elevated the status of inheritance provisions above the rest. And that is very visible in their doctrine of the strength of the dalil, that is the evidence on which the provisions for inheritance are based on. And as you very well know, and the listeners probably also know, the Supreme Constitutional Court employs this distinction that is very common to legal scholars, fuqaha, between the ahkam, that is the rulings that are based on evidence that are certain in their origin and interpretation, qat'i thubut wa dalala, and in a way it has always refrained from applying it to any legislation passed after 1980, which gave the legislator a wide array of options in terms of how they could actually legislate on matters relating to Sharia, except for inheritance provisions. So inheritance provisions, they said, those are based on dalils that are qat'i thubut wa dalala. So in a way, they elevated this provision to a space where the legislator cannot intervene. And that has happened in a case in 1998. It was a case that struck down a legislation that was already abrogated, so the consequences were not major. Most of the scholarship hasn't really looked into this. And then more recently in 2018, on a case that had to do with the agricultural reform. So again, very marginal issues, but this very continuous, constant stance on this. Now, this in a way aligns with the position of the Court of Cassation, another apical court in the Egyptian legal system. And the court, since the 1930s, has been sort of consistent in saying inheritance rules are a matter of public policy. again, elevating the position of inheritance provisions sort of like above the regular provisions of in other areas of the legal system. Now, what is sort of striking is that in obiter dicta of the court insists on the fact that it's so much important for the legal system that it applies to both. These inheritance provisions are so important for the legal system that they apply to both Muslims and non-Muslims alike, which, of course, it's particularly surprising or shocking because this comes after the constitutional reforms of 2012 and 2014, which have, of course, introduced a specific provision about the sources of legislation on personal status for non-Muslims in the country.
So basically, in Egypt, Christians enjoy legal autonomy in matters of family law, so issues relating to marriage, divorce, child custody they are governed and subject to their own laws. But then in the area of inheritance, it has been contested historically, but in general, the Islamic inheritance laws were applied at least since the 1940s to Christians. And then you mentioned this reform of the Constitution in 2012, which introduced an article, Article 3, which declares that the principles of the laws of Christians and Jews shall serve as the primary source for their personal status laws and religious affairs. And a lot of Christians lobbied for this article because they were hoping this would open the door for them to be allowed to apply their own inheritance laws. Recently, the Court of Cassation has issued an important ruling on this. Could you elaborate?
First of all, you mentioned the question of legal autonomy, and I think that what is fascinating about these latest developments is precisely that it forces us to think or rethink about, what are the boundaries of this legal autonomy. Because in a way, if you think about it, and you've just mentioned Article 3, Article 3 says that there's one piece that was missing in your recitation of the provision, which is it's the main source for the legislation on personal status. Mm-hmm. Now, the tashri'at, that is not minor in the sense that it sort of claims, or it empowers Parliament to legislate on matters of personal status for non-Muslims, which in a way is limitation to autonomy, because it means that now it's the state that has the right to legislate on matters of personal status for non-Muslims. So in a way, it's a shift away from the idea that non-Muslims have a different position vis-a-vis the state, and so state authorities have, in a way, a lesser say in how they organize their own internal affairs, including family law and personal status. So Article 3 is not just, to me, it's not just, well, in a way, it is a parallel to Article 2, because Article 2 empowered the Parliament, or broadly speaking, the legislative authority, to intervene on matters of Islamic personal status. So in a way, the legal autonomy of Christians in Egypt has changed after 2012, but as you said, it was very strongly advocated for by large sections of non-Muslims. When it comes to the question of personal status and what applies and what is included in it, again, that's another fascinating matter, because when you actually look at one of the early incarnations of treaty, which was meant to be like a textbook on personal status, the Muhammad Qadri Pasha's Al-Ahkam Al-Shar'iyya fi al-Ahwal al-Shakhsiyya, he included provisions on bequests and inheritance in the articles, because it's drafted in articles.
Yes, so the question is inheritance part of personal status law and religious affairs, right? And Christians have been making the argument that it is, but you could also argue it from a different angle.
Exactly. So in a way, historically, it has been a part of Historical is in a way is a big question. But definitely, since the 19th century, inheritance was considered part of personal status. But as you correctly mentioned earlier, there has been a consistent application of inheritance provisions from Sharia to non-Muslims. And that was the case until the issuing of the law of 1943. And the law of 1943, in a way, codified a practice which was the Sharia courts which at the time existed, had jurisdiction on matters of inheritance of non-Muslims, except in the case in which the heirs agreed on being governed by a different law. And that, in a way, sort of changed with the Civil Code, because the Civil Code has this provision, Article 875, that in a way seems to exclude the possibility of agreeing on the application of a different set of provisions. And that's probably also, and again, that was in line with the Court of Cassation position from the 1930s onwards. But then, as you said, there's something striking about this decision in 2024, which is why, after these significant changes in the constitutions, would the Court of Cassation feel the need to reinforce this position of distinguishing inheritance provisions from the rest of personal status and elevating it to a question of public policy?
Why do you think the state has been more reluctant to grant Christian communities autonomy in inheritance matters than in matters relating to other, areas of family law?
Yeah, well, I think that, again, this is why I think it makes it an interesting entry point to understand wider dynamics of legislation and legal reform in the country, because we can access it from the lens of Christian succession law or inheritance law, but actually tells us something more about the position of inheritance. So it's not just a question of reforming inheritance for non-Muslims, it's also the question of reforming inheritance for Muslims. So, and the two, of course, do not go undivided. And of course, in the last couple of decades, we've seen in the broader region a number of movements and attempts to reform the inheritance provisions for Muslims. And we've also seen the resistance to that. So in a way, the idea of separating the inheritance provisions from the rest of personal status and giving it enhanced status, it's not just a matter of, okay, this is a specific issues that we have with Christian inheritance laws, but rather this is a broader concern that we have about the reform of inheritance system for all citizens.
Yeah.
So I don't see it as specifically for Copts, but rather of a broader, wider issue. And so much so that the case law that brought me to this from either the SEC or the Court of Cassation are actually about Muslim succession law, not...
Yeah, it's so interesting. We often understand legal developments as a dynamic of majorities imposing on minorities. But as you just said, seemingly reforming the inheritance laws of minorities could then lead to broader discussions in the society at large, and could also lead to demands for Muslim Islamic family law reform. So yes, it is a national issue. It's not something that just concerns minorities. So what does this tell us about interreligious relations in Egypt? So discourses on national unity often hinge on emphasizing what unites Christians and Muslims, portraying them as culturally alike, and emphasizing this real unity. We are all Egyptians. We don't want to be divided. The introduction of separate inheritance laws for Christians in Egypt would, of course, underscore religious difference and probably add a layer of division and undermine this claim to we are all equal. because, of course, as soon as you introduce inheritance laws for Christians that advocate equal inheritance shares for men and women of the same degree of kinship in many cases, you then introduce new inequalities, in this case between Muslim women and Christian women.
That's a very, very important point that you're making, so thank you. I think this also casts light on the fact that on why these inheritance provisions or succession provisions became so, in a way, totemic. I use this expression, totemic. Because when you actually hear outside of the discussion on legal reform or anything of the like, discussions or the let's say the broader discourse on national unity, the fact that inheritance provisions apply to both Christians and Muslims, it's usually used as evidence of that particular unity. So, we're so much brothers then and sisters that we, even decided to be governed by the same inheritance provisions. So you actually is in a way used as a reference point or evidence for the fact that this national unity exists. So very important into the broader discourse that you just mentioned. I'm not entirely sure of how actually deep this discourse runs in the actual day-to-day interfaith relations, but certainly this is in the official discourse. This is very prominent. And so in a way, of course, challenging it's not just challenging the provision on inheritance, but rather challenging the broader official discourse on national unity.
Yeah, and then of course, the Christian communities themselves, they are not unified on this position, right? I mean, I heard over and over again from interlocutors in Jordan that they are actually happy with the application of Islamic inheritance law, especially by men. And one church court judge told me from Monday to Saturday, I'm a Muslim, and on Sunday, I'm a Christian, emphasizing, there is a cultural understanding that is shared across communities, the idea of men being the breadwinners of the family, and therefore they should be entitled to a larger inheritance share. And this feeling is broadly shared. So we should also be careful not to portray these demands for inheritance reform as unified within the Christian community.
Yeah, I think that your work on Jordanian reforms specifically casts a very important light on this issue. And again, it helps us to rethink the way in which we conceive of reform and also the various motivations behind it. So again, your work in that is, has finally cast some light on these issues. And so thank you very much. It's very important for all of us. Thank you, Dörthe.
Minority law reform or reforms of personal status do not happen in a vacuum. The question of minorities has been politicized during the colonial period in many countries in the region. To what extent is this true in Egypt, and does this politicization shape contemporary debates?
Definitely. And in a way, it is mirrored in a very strong sensitivity against the very term minority. And this, as you said, has historical roots that perhaps go even further beyond the colonial period, because in a way, the idea of protection of minorities is something that European powers would do even before a proper direct colonial intervention, was something that goes back a long time. So definitely there's a lot of sensitivity. I remember that after the revolution in 2011, there was a lot of panic about the idea of dividing the country based on the demographic presence of Christians in some areas. And of course, the example that was often brought was the division between Sudan and South Sudan. So it's a very sort of like tangible, immediate incarnation of these older dynamics into a much closer to us reconstruction of political units. So definitely there is this very strong sensitivity. We can see it also in documents of interfaith dialogue. So for instance, the document on human fraternity, that's where Al-Azhar has inserted into an interfaith document its dislike of the use of the term minority as something that would, introduce a negative perception, because they claim minority, just like in English, includes the concept of being less, minor. I struggle a bit with this because the whole thinking, from the perspective of legal theory and constitutional theory, the idea of minorities was actually strongly developed by Jelinek, who was an Austrian Jew, and he chose minority as a term that was actually important. It didn't feel the negative, dynamics or connotations of it. And then out of that, of course, in the context of the Council of Europe, but also the European Union, we have a set of provisions to protect minorities, because there's a sense that the variety or the diversity that minorities bring to the social fabric is very important and needs protection. However, I think we need to acknowledge precisely what you said, that is, that there is a historical element to the use of minority in the region. And so we have to acknowledge that. And if there is a sensitivity against it, so be it. Part of my concern is that I do not see an alternative concept that is strong enough to actually allow for a shaping of protection for non-majorities. So for instance, in the Egyptian case, very early on, and the Coptic Church actually strongly embraced it, the alternative was considered citizenship, muwatana. But for instance, again, going back to my work on the case law of the Supreme Constitutional Court, definitely not case law, is that they actually never used the provision on citizenship, which is actually Article 1 of the Constitution. They actually never used it to actually articulate a theory of shared or communal life between majority and minorities. There is, in literature, however, there has been a very interesting position by a very prominent legal scholar who passed away, Tariq al-Bishri, who actually tried to provide a shared reading or common interpretation between Article 1 and Article 2 that is emphasizing citizenship. What does that tell us about what kind of mabadi Sharia al-Islamiyya that we can actually use and implement through the work of higher jurisdictions? But that has been in a way isolated, and I haven't ever seen in the case law of the SCC any proper engagement with Article 1.
Yeah, it's interesting. I've encountered this perception that the term minority is discriminatory in a way, and Arab Christians would always frame their demands for reform as part of citizenship, exercising their full rights as citizens, and emphasizing Arab unity. We are Arabs, we are part of the national fabric. We don't want to engage in sectarianism and create divisions, which is always very important, especially when you argue for separate laws that could potentially divide people. But then, as you rightly said, there is something about the term power minorities, right? Like, we don't have a good concept to really capture that the position of numerical minorities is often distinct. And this is, I think, captured in the term power minorities to a certain extent. We see these dynamics play out, for example, with respect to reforms, how reforms are articulated. So the position of the church for Christians is much more important than the position of Islamic religious institutions for Muslims when it comes to reform, because you cannot marry outside the church, you cannot divorce outside the church. So Christians are much more dependent on their religious institutions, also because sexual relationships outside of marriage are not allowed. So it's important to be able to marry, and this gives the church quite a powerful position. And adding to this is the perception that churches do provide a layer of protection in an unsecure regional landscape, where minorities or communities have often been victims of violence, be it in Iraq, in Syria, and suffered particularly during these violent conflicts. So often I found that Christians have been reluctant to articulate demands for reform because they are unhappy with the laws that are there and they see them as discriminatory, but they are also see the church as a source of protection. So there is this double shift. You want to articulate your rights as citizens, but you're also, in many issues that are very central to your life, very dependent on your religious institutions. And since the state is not the lawmaker for Christian communities, you depend on the leadership of the church. And yes, we need a better term, but I wouldn't give up on minority entirely, I think.
Well, I think that what emerged from your comments was also the question of who has the authority on legislating, which again brings us back to the earlier part of our conversation. And in a way, this idea of then political minorities and political majorities. Let's imagine then, parliaments have the right to legislate on matters of, for instance, Christian inheritance law, right? Who votes in those decisions in parliament? So that, in a way, brings us to the wider setup of the constitutional structure of the state, because in a way, the idea of having constitutional provisions is by definition, a counter-majoritarian protection. So there are certain things that majorities cannot do. So that's the very essence of constitutionalism. So it interrogates the functions of the constitution and how it actually plays out in reality. And that's, of course, a large challenge.
We have a notion that we select our research according to objective criteria, and of course you and I always do that. But in the end, research is also personal. What made you become interested in Egyptian law?
Yeah, well, it's definitely a very personal story in the sense that because as we all know, Egypt is sort of the giant in the region for legal studies. I mean, any discussion about law and legal theory, sooner or later we go through Egypt. However, it's not until I actually moved to Egypt that I started really, really appreciating the incredible trajectory and history of law in the country. So it sort of grew on me slowly. And I always say that to me, the barometer of my integration in Egypt was how much Egyptian I spoke. So at the beginning, I would speak Shami. And for a long time, I naturally spoke Shami.
The Levantine dialects.
Yeah. And then I slowly started using Egyptian words with the Shami accent, and then I eventually surrendered to the power of Dunya. So it's very personal in the sense that I think the size and the importance and the depth of the layering of law and legal thought in the country really, really attracted me. And then it's also a broader matter of wider normativities. The other thing that struck me when working in Egypt, especially in the law school, was that there was this very strong feeling and attachment with the French model. And so to me, in a way, it's a very strong ossification of the French model, and usually of a specific period. So it's very hard for you to find, for instance, a textbook in law that wouldn't cite certain, positions of the French Conseil d'État, for instance, or French Court of Cassation. But then what strikes you is that those references, in a way, stop. So it's a very early engagement with the model, and then it's as if it ossified. So I think that what makes, the Egyptian case interesting, not just for me personally, but also I think it should be studied more closely also by those who are not necessarily interested in Egypt as a country, is because it provides an example of what very specific, strong version of civil law can actually be and become, without the sort of measures that can mitigate that sort of extreme version of civil law that we may have in the development of French legal thinking. And so in a way, to me, Egypt is a very extreme incarnation of a civil law system, which of course intersects with us in the last decades, with a strong embracing of a very unregulated capitalist involvement. And of course, there's also other factors. So in a way, it's an interesting case that speaks to wider context, not just Egypt. So yes, so my entry point was very personal, but I think it has something to tell to beyond its borders.
But it was your love for Egyptian law, not koshery, in the end.
Well, the problem, well, yes. So I had too much koshery.
The Egyptian national dish.
Yeah, which, it's also pasta based, so it speaks to my, to my Italian roots.
True.
So that was my lunch when I was working in the library during my doctoral years. And once I had too much kushari, so I can no longer have kushari. However, I can still do law. So, so it's definitely beyond kushari.
Gianluca, thank you so much for being here and sharing your wisdom.
Thank you, Dörthe. It's been marvelous. Thank you.